Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call where everybody is welcome to join in and participate, ask your questions. Today is June 11th. Um, we had a database corruption this morning, actually late morning. So they're working on bringing the forums back up. What I'm going to have to do is, since we have lost all the questions that were posted on the forums for now, I hope that a lot of you are logged in. Um, and I also know that some people could not even get the telephone numbers to call. I did tweet the number. I posted the number of the conference call on Google Plus as well as on our Facebook page. So some of you were able to find your way here, some of you were not able to. I'll have to do the calls on the spot. So whatever questions you have, whoever is here, whoever was able to make it, will answer them in the order that you logged in. So if you want to ask me any questions right now, please press *5 on your phone. Press *5. *5 means you have a question. 1, 2, 3 people, 4 people, 5 people. Okay. I'm sorry that a lot of you could not even make it because you didn't have a phone number to call. But if there's something urgent, I'll try to make up for it and provide answers as we go along during the week. Okay, let me get started in the order you folks logged in. Missouri, go ahead, please. Missouri.
Hello.
Go ahead, please.
Hi. So I have a question about my aging out. I turned 21 recently, and I'm just aging out of my parents' file. So they had a EB3 filed, and the 140 got approved in January, and then they filed the EB2, and that got approved recently. And my question is, when they did the EB2 and they did the 140 application, I wasn't included because I already turned 21 by that time. But for the EB3, I was included in it. So I wanted to know, like the pending date for the 140, there's around 177 days. If that could be used for the new 140 that was filed, and I can be included in the application.
Okay, this is what I have understood you to say. One of your parents, there was a little bit of a breakup in the call, but let me sum it up and try to understand if that's what you asked me. You said that one of your parents had an EB3 application which was filed and you were under 21 at that time, correct?
Yes, that's correct.
Then there was subsequently an EB2 filed, but you could not be included in that because you were over 21 by that time, correct?
Yeah, that's right.
Okay, I will not have the time to go over all the details, but I can tell you the law or whatever law I understand. See, under the Child Status Protection Act, CSPA, the law says the number of days an I-140 was pending, the number of days the I-140 was pending should be deducted from your age, and if you are under 21 and your priority date is current, your 485 can be filed. Okay. So let's say you are 21 years and 6 months old when your priority date became current, and your parents' I-140 was pending 7 months. You are fine because now you can file 485. Now, in your situation, we want to take advantage of EB2. When the EB2 was started, CSPA was not protecting you, but under EB3 it was. Can that benefit be carried over? In essence, that's your question, correct?
Yes, that is my question.
And the answer is no one knows. Okay, there is indication. I remember reading this issue a few months ago, and I would have to revisit my research and my notes. I don't remember off the top of my head. You should have your parents' lawyers look into it. But I believe in a situation where you're trying to carry forward benefit of CSPA protection from EB3 to EB2, the law is by no means certain. Therefore, I think you're going to have a problem. Under EB3, if you are protected by CSPA, you are fine. But if you try to import that into EB2, you will not be, at least there's not a clear answer. I think it's a problem. Okay?
Okay, thank you very much.
You're welcome. Good luck. Folks, for those of you who are just joining us, because of the database corruption, we've lost the questions that were posted. So I'll answer everyone's questions on the go. I asked for the first group of question askers or the questioners, and I've got 4 more in that queue. Once I'm done with that, I will invite more questions. Texas, go ahead, please. Texas.
Hello, hey Rajiv. My question is with regard to H4 amendment, the process. So I just recently changed my job from location A to location B, and both these locations, my end clients are in the same city, like in Dallas. So do I still need to file an H4 amendment?
I had a discussion about this just 20 minutes ago with a client, and I'll repeat what I just told them. Let's look at the law. Where does this requirement of amendment come from? The requirement of amendment under USCIS regulations, which are found at 8 CFR 8 Code of Volume 8 of the Code of Federal Regulations, and I believe it's I forget the section 214. I forget the section. Anyhow, in the regulations, USCIS says if there is a material change in the terms of the H1, you have to file an amendment. Now, I'll give you the bottom line of your situation. If you look at USCIS's interpretation that came out last week, because your move is within the same geographical area within normal commuting distance, they are saying you should not have to file an H1B amendment, but an LCA has to be posted at the new job site. But I think USCIS is wrong. I'll tell you why they are wrong. I think they have missed an important point, and they have failed to cover an important point. I think there is no doubt if the project is the same, end client, vendor, everything is the same, and you just move within a few miles within a normal commuting distance, there is no need for an amendment. That's quite clear. But what if the project changes? What if the end client changes? I think the more appropriate statement of law is that in those cases, you should be doing an amendment, even though it is in the same geographical area. However, USCIS has not said that. If you look at their memorandum and their interpretation, they say if the move is within the same area, you should not have to file an amendment. My advice to our clients this morning was, please go ahead and file an amendment, because if USCIS messes up and gives you incomplete information, they may not be able to act and punish you or your employer, but they can certainly consider you to be out of status because an amendment was not filed. Why take a chance? It's a few $100s. It's worth a shot. I personally believe an amendment should be done. However, a lot of lawyers would disagree with me, and I cannot say that they are wrong. Clear?
Clear, sir. Thank you.
Good luck. Let's go on to the next question. This is Alabama. I love how many states are represented in our calls. Alabama, go ahead, please.
Hey, Rajiv, I have a situation here. My then girlfriend came to the United States on October 2015 in a B2 visa. She came back in December. On the second visit, we got married and she went back. Now we are looking at the possibility of her coming here in either H4 and get her 485.5. My I-140 just got approved recently. So what do you suggest? Should I call her up on S4, then change it to the 485, or should I call her? She already has a B2 visa and file our 485 together from here.
I think H4 because USCIS can take the position that this is an inappropriate use of B visa. So yes, please go ahead and get an H4 done. That's my opinion.
And will there be any questions like why did you get married on your second visit as a tourist?
Even if there are questions, my advice would be please don't conceal anything from the government. Answer their questions truthfully. If you tell the truth and they raise any objections, I think we can handle them. I don't think it's going to terminate the case in any way. But if any lies are discovered, it's a permanent bar from entering USA. So whatever questions they ask you or your wife, make sure you respond truthfully. I do not think this is going to be a big problem. Okay?
Okay, sure. Thank you.
You're welcome. Good luck. I have two more questions and then I'll invite a fresh set of questions. I know a lot of you have just logged in. Um, Once I'm finished with the first set of questions, we'll start on the new ones. I tweeted, I posted on Google Plus, I posted on our Facebook. We had a database corruption, so we've lost the question that people had posted. Hopefully, if you're logged in, I can answer all your questions right now. Okay? So I'll get to you in a minute. Kansas, go ahead, please, Kansas.
Hi, this is Ramesh. Thank you for taking my call. The question is about, my wife and kids had to travel urgently to India, and their advance parole was pending. My wife's advance parole was pending for a very, very long time, but we didn't want to wait for it, and now we went out of it. Now, the thing is like the 485 dates are current. I filed it in EB3 in the year 2004, and now my dates are current. Now I want to see, is there any way I can file counselor processing on my own, or I have to wait for the decision on the 485 and then file counselor processing?
Okay. So the situation is your spouse and your child could not wait for the advance parole to be processed. So even though the 485 was pending, they left the United States, correct?
That is right.
And they don't have an H4 visa stamp, do they?
No, they don't have exports.
Okay. That means,
I mean, it's basically only my wife.
okay, that means the 485 is deemed to be abandoned. All right. So your
Right.
understanding is correct that you'll have to convert her to consular processing, or you have to convert back to H1 and get her back on H4, then apply her 485 again. Okay. So
That is right.
two choices. And if you decide to go consular processing, you don't have to wait. You can have your lawyers file a form I-824 following to join right now. Okay.
Okay.
Do that so that
Okay.
there's as little time gap as can be possible for them to be outside USA and be able to join you as quickly as possible. Okay.
Can I do the I-824 myself?
I usually like lawyers to handle these cases, even though it's a simple form. It can get kind of complicated further along the line. I think you should get a lawyer.
I should get it done through a lawyer. Okay.
I think so. And all the way to the end of the
And
process. Go ahead.
and I don't have to wait for mine to. I don't have to do mine and consular processing because I'm still in the country.
No, you can split it. You do adjustment 485 while your wife does consular processing. That's very common.
Okay.
All right.
Okay, that is wonderful. Thank you.
Good luck. Okay, the last question of the first batch, then we'll start the second batch in a minute. Georgia. Georgia, go ahead, please.
Hi, my question is about the H1. So my H1 was filed in the master's quota, and I graduated from Stratford University. Now the situation is that my H1 extension is due in next March. So and then I changed my client, so I have to file for H1 amendment. And I think there are problems coming for all those people who had applied in master's quota. They should have applied in Chancery quota. I wasn't aware of it at that time. So I'm trying to understand what are my options through which I can stay here legally. Should I go for H1 to F1 without filing amendment right now? Should I just go to file for change of status? Or should I apply for H1 amendment, let the RSP come, and then request for change of status? Or yeah.
Okay. Um, First of all, this is actually about the fourth time this morning that this issue has come up. Three other people have uh, raised this issue in emails as well as in consultations. So this is a difficult, and I've told every one of them, I don't think I have an easy answer for you. Um, Typically, when the university or the degree is not accredited, um, government takes the position, or it's not a public university, non-profit public university. Government takes the position that you should not be in the master's degree quota. If they have given you the quota exemption erroneously, they are not going to perpetuate it. They're not going to continue to give it to you. Okay. In the cases that we dealt last year, we had 4 cases like this we handled. 3 of them we were able to win. 1 we lost. How did we win? We didn't really do much except pointed out to the government that this is your error. Why are you punishing our clients for it? Mixed in some law. I don't by any means encourage you to hire us to do this or retain us to do it, because I don't think we can save these cases. I don't even know why we won those cases that we did win. Legally, the government is justified. Okay. You can try to make the argument, ma'am. You can try to, if the RFE comes, you can try to, but I think it's a losing case. If you want to convert to an F1 while you still have H1 status, that's a good idea. I like that idea. I don't like the idea of fighting a losing case and then not have status at all. Okay.
Okay. So you think that going from H1 to F1 right away, like right now, is better option rather than taking the risk of applying for amendment?
From whatever data I possess, that seems to be the best option. Yes, ma'am.
Okay.
All right.
Okay, cool. Thank you so much.
You're welcome. Good luck.
Thanks.
Okay, let's start the second batch of questions. Anybody who has any question, press *5 on your phone, please. *5. Anyone who has any question, press *5. Remember, *5 operates like a toggle. So if you press it once, I see you. You press it twice, you're gone. So press *5 only once. So far I have 5 more people. 5 more people. Alrighty, let's, 6, okay, 6 more people. I am going to go in the order in which you folks logged in. Alabama, I just spoke with you. Go ahead again, Alabama.
Hey, Rajiv, this is Shiraz again. I just spoke to you a while ago. So regarding that B1, B2, applying for the H4 visa for my wife who has already visited the United States, what would happen if her H4 get denied? Will her B2 also get revoked?
Technically, let me start with the bottom line first. Um, Consulates should be doing it. They should be revoking existing visas before considering an application for the next visa, but they usually don't do that. Okay. So whenever somebody applies for an H4 visa and if there's a B stamp, consulate should cross that out before they even take the application. That doesn't mean you can't apply for B2 again if the H4 is denied, but that simply means that's the normal standard operating procedure. However, as a practical matter, I know of very few cases coming from India where they actually did that. Usually they don't disturb the tourist visa, they let it alone. Okay?
Okay. So if she got denied for the H4, can I file my 485 here and send her invitation to join in the consulate because I already have my
Right.
one
Exactly.
I-140 approved.
That's the right thing to do. You don't have to wait for the 485 approval. I just told that same thing to another gentleman. I just said you can file the 824 even while the 485 is pending, as long as the priority date is correct. Okay.
Yes.
Anything
Right.
else, sir? Anything else?
No, that will do for me. Thanks, Rajiv.
You're welcome. Good luck. Okay, let's go on to the next question. This is New York. New York, go ahead, please.
Hi, I wanted to check on the G4 status. My wife is on G4 visa. She works for international organization, and I have to switch from H1 to G4 because that's the requirement. My employer has started my 140, so I wanted to know, being an dependent G4, can I continue my green card process through my employer because the primary G4 holder is not entitled for green card process?
No problem at all. We've done it many times before. Actually, even the primary can
Okay.
apply, but the way it works is, as a G4 holder, you are not subject to US taxes. And if at all the primary is subject to US taxes, the organization pays those taxes. Correct?
Yeah, but I'll be filing through a
Okay.
private
Hang on. Let me just go on. This is part of something called privileges and immunities. That means you have certain special rights. Okay. When you file your 485, at that stage you'll have to surrender those privileges and immunities. But you can absolutely process your green card, no problem at all.
Okay.
All right?
Thank you so much, Rajiv.
You're
This is
welcome. Good
really
luck. Okay. Um, it's kind of interesting how much law you pick up in years of practice. Um, I don't remember the last time I actually had to look up the answer to a question, as long as it is in employment based immigration or some complex immigration area. All right, getting back to that, let's go to Connecticut. Another interesting thing is I've answered about 9 people, and these were from 9 different states. This is the ninth state, Connecticut. Connecticut, go ahead, please.
Yeah, hi. Actually, I came through a company from India and working in US. And actually, I was searching a job, and I got a job. So they had filed my visa and premium processing, but unfortunately, it went in RFE. So I was worried about that time. So I started searching again the job, and then I got a job in company B. They had filed my visa in normal processing a week before. Now, what is happening? Company A, who has filed my visa and premium, that visa got approved. But unfortunately, I don't want to join that company A now. I wanted to join a company B, which has processed my visa in normal processing. Now, question is, the company B receipt is yet to be received, which is going to be coming next week. And if I go and join company B, is there any legal issue which can be turned on by company A if I don't join there?
Okay. So your question is, I'm not addressing anything other than one question you asked. You asked me
Yeah.
if two companies filed for my H1, one filed premium processing, it got approved, second one is still pending. I want to join that second company. The fact that my H1 got approved, does that make me legally liable in any way? Is that what you asked me?
Yeah, yeah.
Okay. And the answer is, unless you have signed a contract of some kind that requires, I mean, reimbursement they can't require, but they can always sue you for actual damages. So, yeah, definitely you are open to a lawsuit for breach of contract if there is a contract. Um, but all of this is subject to state laws. Under immigration law, there is no liability.
So, so if I don't join the company A whose H1 is approved, next they can ask me to pay the amount of the H1 processing, and next package can happen. But
I
it won't create any problem in the visa transfer which is normal
Well,
processing.
now the question has changed. Okay, let me address it in a different way. First of all, I don't know the law of the state you are in, where the contract is, etc. Nor am I admitted in every state in the country. So I can't comment about state law, but generally speaking, if an employee having either entered into a contract or made a promise that I'm going to join you does not join, they can of course be sued for actual damages, which is if we paid any money out. Although the fees, etc., for the H1 process, including attorney's fees, are probably not recoverable since the Department of Labor believes the employer should be paying for those. However, they can sue you for damages like loss of goodwill and consequential damages because you didn't join, they lost the whole project. If somebody is gonna be mean, they can be mean to you. Okay, I can't predict how that would play out. You should talk with a lawyer locally and discuss the contract aspects with them. But as far as immigration law is concerned, that's a totally different ballgame. Let's look at the immigration law issue. That's the only issue there is the issue of status. So you entered USA on company number one's H1, correct?
Yeah.
Did you start working with company number one, or did you apply through company B right away or company A right away?
So the company on which I came in US, I'm still working with them as of
Okay,
now.
then there
They
is
are
no
not,
problem.
I have
Then,
not resigned there also.
okay, hang on, hang on,
But
sir. Let me finish. I got what I needed to know. If you are continuing to work for the company who sponsored you and whose visa you entered, and there are all these other players who are applying for H1 for you, if you decide not to join any one of them because you are still working for the company number one, there's absolutely no immigration problem. You can decide not to join the second company. You can even decide not to join the third company, even if the H1s get approved.
okay. So sir, one more question. Actually, I am deciding to join the second company for which the H1 is applied in normal processing and receives active come.
You want to join that company? Is that what you said?
Yeah, second company.
Okay, I'm thinking of that as the third company, but that's all right. You see, you can
Yeah.
join them. I guess the safest thing is when the receipt comes. The safest thing is when the approval comes. Because if you join them and then that case is denied, you would be out of status. You would have to go outside USA
Yeah.
and come through another H1 visa. Okay. So the safest
Right.
thing is to join them only when the case is approved. If, however, your lawyers think that it's a very strong case, it won't be denied, you can certainly take a little bit of risk and join them when the receipt comes, which is the safest thing to do. Number two safe thing to do. Okay.
Mm-hmm.
Anything else?
No, sir, next I can conclude is if the company for which the H1 is approved by transfer, they can just sue me on for the attorney charges, the H1 transfer, if I don't
No,
join.
I did not say that. I said that is a state law issue.
Okay.
There can be an exposure.
Okay, I mean, problem.
There can be an exposure of actual damages as well as consequential damages, such as loss of goodwill, loss of project. I do not know. That's something you have to discuss with your state lawyers. Okay?
Okay, yeah,
Good luck.
yeah. Yeah, thank you, sir. So this is the last question. The state law is if I'm living in Connecticut, I have to talk to the Connecticut state law, or the company is available in this particular
See,
state, have to talk to the state law.
normally the contracts in the last few paragraphs will say this contract will be governed by the laws of the state of California or whatever. So see what that state is, get a lawyer in that state. Okay?
Okay, yeah,
Good luck.
thank you.
You're welcome. All right. So we have three more people. Let's go to Georgia. Georgia, go ahead.
Hi Rajiv, I have a EAD and my 485 is pending and I got the CAD in 2007 when the dates was current.
and my H1 status is no more, and I'm still working for the company on EAD. My question is, I have a Canadian residence, and just wanted to find out if I uh, go to Canada and stay there, for a Canadianship, for applying for the Canadian citizenship. And then, is there any problem in my 485 if I stay there?
Uh,
And once I have my EAD and advanced parole approved, then I can stay out of the country. And then when before they expire, I can come into the country and apply and then go back and stay for whatever the time required for the citizenship there, as long as I'm continuing the job remotely.
um, the answer is yes, I think that should be fine. So let's go over the facts. The fact is that your green card is going on, 485 is pending. If you get advanced parole, it's good for let's say 2 years. Up to 2 years, you could stay outside USA in Canada and continue to do your job remotely. I don't think it causes any problems for your green card.
But I can stay only for 1 year, right? Because the advanced parole is for only 1 year, right?
1 or 2 years, I don't know. I think I've seen 2 years also, but I'm not sure. I believe it's whatever the number of years is. If you get it for 1 year, then you have to come back within that year, renew it, and then leave after you get the approval. If it's 2 years, you can stay abroad up to 2 years. Okay?
So this is totally valid that I am staying out of the country while my 485 is out of means run.
Definitely. I
It's
don't
in
I
process.
don't see any problem with that. Let me double check something for you.
As long as I have the job continued, right?
Yeah, give me 1 second. Sumanji,
Yes.
I'm on the conference call real quickly. Are we getting advanced paroles for 1 year or 2 year?
Uh, it's a matter of chance. In many cases, we get 1 year, 2 years, and we don't know what the logic behind that is.
Thank you, man. Yeah, that's what I thought. We are getting both 1 year and 2 years.
Okay.
All right?
So, but I have to come before the expiration of the advance parole, right? I have to come into the country before the
You have to come.
expire my advance parole.
You have come to USA, apply for extension, obtain it, only then leave. Okay.
Okay, and while it is in processing, can I leave the country? If my advance parole is processing, my EAD is processing, can I leave the country while it's in process?
Assuming that you leave the country and come back within the life of the previous advance parole, the answer is probably yes, but confirm that with CBP before you leave. Because the last time we had a conversation with them a few months ago, they said in a situation where the original advance parole is still active and the second one is pending and you return within the life of the original one, it's okay.
Okay.
All right.
Okay. So, Rajiv, I can able to leave the country while it's in process. Can you just explain me again if you don't mind?
I can spend another minute. Follow me very closely. This is what they told us the last time. Please double check before you do anything. Okay? They tend to change their policies rather too frequently for comfort. What they said was this: if you have an advanced parole which is still alive, not expired, you enter the US,
Okay.
you apply for an extension, and while the extension is pending, you leave and come back within the life of the first advance parole, they'll accept it.
Okay.
Okay. But if you leave and the first advance parole expires, then the second one gets approved, they won't accept it.
Okay.
All right.
Okay. And same as on the EAD side also?
EAD doesn't matter. EAD, I think, is the
So if EAD is in processing, I can leave the country. It doesn't matter if I'm outside the country also.
that is what we were told. But double check it. For EAD, they said you can be outside as long as the advance parole is valid. You file the application,
Okay.
when you leave, we don't care.
Okay.
All right.
All right, Rajiv. Thank you so much. Appreciate it, your help on this.
You're welcome. Good luck. All right, let's do the last two issues. This one is New Jersey. New Jersey, go ahead, please. New Jersey.
Hi, Rajiv. I have a question on adjustment of status. My I-140 was filed in first preference, and in 2000 January 2014, and then while the I-140 was in process and while it got approved, I was in a different state. Other than the state that was, I mean, I was in the same state, but in a different city mentioned in the I-140 petition. So when the 485 was filed, I came back to the state and the city that was mentioned in the I-140 petition, and I got an RFE recently saying that the records show that you are in a different geographical location. So they want us to submit a letter from the company stating this discrepancy. So do you think I'm with the same employer? I still maintain my I'm still on my H1 visa. I've got an
No
approved
problem. No
EAD.
problem.
So
No problem at all. Okay, wait. Let me clarify this for you. Uh,
mhm.
I just reviewed an RFE that was going out exactly the same issue. But in our case, there are two things that are very easy to explain. Number one, the PERM application that we had filed clearly said that relocation is possible. So when you have a case like that, where there's a relocation possible mentioned in the PERM application itself, it's an easy case to win. Okay, and you can move from place to place, no effect at all. Assuming that your PERM application mentions that, the answer is quite simple. If your PERM application does not provide for periodic transfers or relocations, then it gets a little bit more tricky. Your lawyers would have to argue that green card is for a future job. Where an employee works today is irrelevant. As long as we have the intention of reassigning them to the place of the labor cert filing when they get the green card. So if the labor cert is filed from New Jersey, employee is living in California, when he gets his green card, he will move back to New Jersey. That's good enough.
Okay. So in my case, then since I'm in the same city and the state that was mentioned in my I-140 petition, I think you are saying that there should not be any issue.
I don't think this is an issue at all. So don't worry about it. But do very carefully sit with your lawyers, review the labor cert, the PERM application, and review the RFE. The fact that you were periodically relocated is not a big deal.
Rajiv, I won't have an in first preference, we don't have a form, like we directly have I-140.
Why is that? Did you do an EB1?
Yes, first preference.
Okay, you have an EB1. Are you a researcher or a professor?
Multinational manager.
Oh, you are EB1c, so you are an international manager.
Yeah.
For you, it's no problem at all. EB1c does not confine you to any location. You can be anywhere at all. Your case is even easier to handle.
Okay.
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 All right.
Okay. Thank you, sir.
You're welcome. Good luck. All right. Last question of the day. I'll then invite another wind up before we end this call. So let's do this last raised hand from New Jersey. New Jersey, go ahead, please.
Hi, Rajiv. Thank you so much for the committee survey.
My pleasure.
I have two questions actually at this moment. One is H1B amendment and the other is H4 EAD. So for H1B amendment, my employer filed H1B extension based on A location. Now I work for different clients based on B location.
Okay.
So I checked with my employer. So they are saying this A and B comes under same MSA. So we need not to file the MSA. So is there any way we can verify that thing through some link or like that?
MSA links. Can you tell me the location of the two places? Maybe I know the answer off the top of my head.
So one was Edison, other one is Warren, New Jersey.
That does not sound like the same MSA, but I could be wrong. What you should do is, hang on, let me check this. Amrita, can you step into my office for a second, Amrita? I've just paged one of my colleagues. I'm on the conference call. Real quickly, how do we check the MSAs? Do we do it through FSC Data Center?
Usually, let me just check.
All right. I'll just find out for you. What is your second question?
Yeah, second question is, sir, H4 EAD. I have I-140 approved. My wife, she's also on H1B visa at this moment.
Okay.
So I'm in the process of filing H4 EAD for her.
Okay.
My question is, once the process gets started, first the H4 will come, and after that EAD. So is there any guarantee that the EAD will be approved at all the time? Otherwise, she will lose the status of H1.
No, she will. Yeah, she will lose her work authorization because the H4 is likely to get approved first. However, that's not guaranteed to go one way or the other. They might approve the two together. They might do H4 first and then EAD. They will definitely not do EAD first and then H4. So yes, there is a high potential for there being a gap. Okay.
Okay.
All right.
In this case, you mean to say EAD will get approved like that?
No.
Depends on the situation. Means once H1B H4 approved.
What I'm saying is that there's no guarantee what the order will be. There is a very high likelihood that you will end up having a gap between your H1 and your EAD.
Okay. Okay. And sir, the last thing is, for her, the same case for her as well. Her, location has been changed to the client place.
Okay. Here's what you need to do, sir. Write this down. You need to go to FLC, Foreign Labor Certification, flcdatacenter.com. FLC Data Center. Center is the American spelling, not the European or the Indian spelling. CENTER. flcdatacenter.com. Enter the name of the county where you are working, get the MSA, then enter the name of the county where you are moving. It'll tell you which MSA both are.
Okay. Okay.
All right.
Yeah, sir. Last question was my wife, right? We are in the process of filing her H4 EAD. So does she require for H1B amendment at this moment or not?
Look, I have discussed this issue in great detail in this telephone call. So if you can just be patient and listen to the recording, I should have it up by tomorrow. I have talked to people and I feel that if the client changes, I think an amendment should be filed even if it is in the same area. Okay. If you're filing H4 and she is not yet moved to the new location, an H1B amendment should not be needed. Okay?
Okay. Okay. All right, sir.
Good luck.
Thank you so much.
You're welcome.
Thank you.
Okay, guys, this will be the last round. We've already done 2 rounds of questions. Anybody has any question, press *5 on your phone. *5. This will be the last round of questions. Last round of questions. So far, I have 4 people who have additional questions. 4 people. Alrighty, so this will be the last set of questions I'll be handling today. Let's go to Texas. Go ahead, please. Texas.
Hey, Rajiv, earlier in the conference call, I asked a question about H1B amendment question. Now, further to the question, I just wanted to know, so when I file H1B amendment, is this some form of intimation to USCIS or we are seeking some approval from USCIS?
Okay, good question.
And is there any time period as to when we should be applying for this?
Very good question. And let me begin with the easy one. The time frame is the amendment should be filed before you join the amended location. Okay, so before you join the new location, amendment should be filed. An amendment is exactly like filing a new H1. H1 transfer, H1 new petition, H1 amendment is exactly the same paperwork, same forms, same issues. They can ask you the same kind of questions. Just because they approved your H1 once before does not mean that they will also approve the amendment. they can deny the case. It is just like filing a new H1. Okay?
Yeah, thank you for that. And one question, another question, follow-up question, Rajiv, is I already changed my end client now, so should I be submitting any additional documentation in this case, or how should I proceed?
I personally think you should let your lawyers decide that, how they want to handle it. In some cases, we like to submit all the documentation upfront. In some others, we hold back until we are specifically asked for documentation. So it's a legal decision, not really something I can decide for you. Okay?
Gotcha. Thank you.
You're welcome. All right, let's get on to the last three people. And we are back to Georgia. Georgia, go ahead, please, ma'am.
Hi, we just spoke a few minutes back about the same Stratford issue, and you suggested that I should probably go for H1 to F1. I have a follow-up question. I had applied for my green card last year, and my labor was certified, was approved this year in April, and I think it's just within next 6 months you have to apply for your I-140, otherwise it gets expired. So at this point, if I apply for from H1 to F1, would I still be able to go for applying the I-140, or would it be expiring, or yeah, that's the
I
question.
think that makes the situation tricky because if you have exhibited immigrant intent by filing your I-140, your F1 can be denied on that basis alone. However, I don't see any reason why you should lose the advantage of a priority date. I mean, it's a tough choice. Remember that the F1 can be denied and you'll have to leave USA. The other option is for you to not file the I-140 and lose your green card. So that's a decision you have to make. What risk are you more comfortable with? But there is no way to have risk-free decision and keep both of these things protected. What would I do? I would probably file the F1 first. Once the F1 has been filed, a few days later, I would also file the I-140. Because when I file the F1, at that time, nobody has applied for my green card. So I have the answer to the question, has anybody applied for your green card, would be no. Okay, of course, that could come up during the process of the adjudication that a green card has been filed. But I do know cases, I know many cases where a student visa was approved even though I-140 was pending, even 485 was pending. So, that can happen, but there's no way for you to have any margin of safety or guarantee that it's going to work out. If you want to take one or the other and you're comfortable with that choice, then choose that, which basically means I'm going to take F1 and forget about my I-140. That's one option. And again, there's no guarantee you'll get the F1 even then. But if the I-140 is pending or filed, then the chances are even lesser. Okay. The second choice is
Mhm.
to take the risk with the F1 and say I'm going to file my I-140 anyway. If you decide to do that, I would say the sequence should be file F1 first and then file 485, then file I-140. Okay.
Okay. So, just in case I don't file I-140, that would mean that my labor is going to get expired and I would lose the priority date as well?
That is correct.
Okay.
Good.
Okay. So everything, the whole process would start from the beginning.
That is also correct. Yes, ma'am.
Okay. Okay. Cool. Thank you so much.
You're very
Thanks a
welcome.
lot, Rajiv.
Good luck. Hey guys, you don't need to thank me that much. I mean, I really like doing this. It's fun. So, don't be overly grateful. I do it because I like it. Okay, let's go to California. California, go ahead, please. There are two calls from California. Last two calls. First one from California. Go ahead, please.
Yeah. Hi, Rajiv. So, thank you for all your help on those
You're very
community
welcome.
servers.
You're very welcome, sir.
Okay. And I have a question. My ex-employer took money from me in India for my H1 processing in premium mode, like 3,200. And when I left him up, and he made me sign a contract for 2 years for some lump sum amount of liquidated damages. If I leave him like that, then he sued me in the court. Now my question is, can I put something because he took money for my H1 at the very first
Okay,
place.
hang on one second.
He's threatening me to
Hang on one second. You said you've been sued. Where have you been sued? India or USA?
in US.
I want your lawyer to call me. I don't want to talk to you. I want to talk to the lawyer who's defending you in the state court because I have some pointers that very few lawyers will know unless they know immigration law. And of course, you can join in the conference. I will give you a free consultation, but I need to let your lawyer know how to defend this case. Okay? The taking of the money is wrong. Pinning you down to a liquidated damages clause is wrong. And this whole lawsuit should be thrown out by the judge if it is properly briefed as an agreement which is against U.S. public policy. I want to talk to your lawyer. Okay?
Okay. So how do I respond or reach to you
Yeah.
on this part?
Here is what you do. You send me an email whenever your lawyer is ready to talk. Just tell them that I want to discuss certain issues with them. Send me an email to help@immigration.com. Okay? I'll organize a call.
Okay.
You are, of course, very welcome to join. I will even record the call if you like. You guys can have a recording and then proceed along those plans. And if your lawyer needs to contact me from time to time, I will be happy to volunteer my time without charge. I am sick and tired of employers who take advantage of employees. Okay?
Okay.
So
Thank
just,
you, sir.
you're welcome. Don't worry, you have some very solid legal arguments in your favor.
Okay.
Good luck. Okay, the last call of the day, folks. Also from California. California, go ahead, please.
Hi, Rajiv. I am from California. I had a question regarding my wife's status. She is working on L2 EAD now through her employer. She applied for H1 this year and it got picked up, but not through her employer, but through another consultant. Um, so we have the receipt number that the consultant shared with us. Our desire is to kind of continue with the current employer. Is it possible to kind of transfer that H1, the receipt number that we have,
No.
after October or
No.
before October
No,
to the current employer?
until the H1 is approved, you have nothing. Okay. Once the H1 is approved, as long as you file a second application before that is revoked, you should be able to carry that H1 forward. Okay. But receipts cannot be transferred over from one employer to another. Approvals under limited circumstances can be. Okay.
Okay.
Anything else? Yeah.
So 1st October is the start of the status, right, for H1. So would she have to join that consultant first and then
Okay, now
transfer it
here
to?
is, let me sum it up to you again. This is something I want your lawyers, your wife's lawyers to double check. What USCIS told us the last time we spoke with them on this issue, they said this. They said if the second employer files an application for a changeover of the H1 to them before the H1 is revoked, before October 1st, we will accept that case as being quota exempt. So there are two possibilities. One is you are filing second H1 before October 1st. Other one is you are filing after October 1st. They said if you file after October 1st, we don't care whether the old employer applies to revoke the H1. We don't really care about all that. Okay. Now, if your wife has not joined them, that could get tricky. That's something that needs to be resolved with your lawyers because typically you've got 60 days to join after October 1st. If the H1 is filed within those 60 days, maybe there's a good argument to not have a problem. Otherwise, it could be a status issue. However, if you file the application before October 1st, it is important that the application for the H1 must be received by USCIS before the old employer revokes the H1. Are you clear?
Okay, but if it is filed after 1st October, then even if it is revoked, that's not an issue.
That's what they told me. That's what they told me.
Okay.
I never trust them. Because you know their advice is what it is, so it's always a good idea to double check. In fact, even if we know the answer, we'd like to double check because from time to time their policy could change. Double check it with USCIS. I think you'll be fine. Okay.
Okay. And I have another small question, Rajiv, if you have time.
I have about 5 more minutes, then I have to go. But go ahead.
Okay. So the quick question is, I actually applied for my H1 in 2013 and got selected. But although I continued on my L1, I exited the country and came back, and I continued on my L1 with my current employer, and my H1 was approved. So I still see, when I see that receipt number in USCIS, it says it was approved. There's no further action on that application after that. So if I wish to go on H1 now, I can still use that number.
Let's talk about that a little bit. Let me understand this. You had a change of status to H1, did you?
It was applied in April 2013. It got approved in July.
No, that's not the question. That's not the question. The question is, had you applied also for a change of status? Okay.
Yes.
Here's what you need to do.
2013, it was applied as change of status.
If indeed there was a change of status, I think, when was the H1 approved?
It was approved in July 2013.
Okay. I think you are quota exempt, but have your lawyers double check this, please. Okay.
My quota is done.
Yes, you are quota exempt, no longer subject to the quota.
Okay.
Okay.
So if I want to use that quota from 2013 with my current employer, what do I need to tell them?
Just tell your current employers that you're quota exempt because you have an H1 approved for you. All right.
And if the consultant who applied for my H1 had withdrawn the application or done something with that beyond October 1st, would that matter?
I do not think so. I do not think it matters. Okay?
Okay. This is helpful. Thank you so much.
You're welcome. Good luck. All right, folks. This is it for today. We'll see you in 2 more weeks. And I always enjoy talking with you. Thank you for the opportunity to be here with all of you. We have a problem. I just got a text from Monica. They are still working on the database correction. Something wrong with the forums. One of the tables got corrupted and it kind of locked out the entire database to us. So we are working on that. Sorry, I didn't have all the questions in front of me, but we still had an hour-long conference and we were able to answer everyone's questions. I'll see you in 2 weeks, next to next Thursday. Thank you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.